Question 1. What factors determine the ethical and legal boundaries for using photography and videography to market a residential property for sale in British Columbia? Option A. Employing advanced editing techniques to significantly enlarge the perceived size of outdoor spaces and enhance the overall aesthetic appeal beyond reality. Option B. Utilizing professional staging and lighting to create an illusion of modernity and recent renovation in areas that are actually outdated and require significant work. Option C. Strategically omitting any visual evidence of less desirable neighboring properties or potential environmental factors that might negatively impact a buyer's perception. Option D. Ensuring all visual representations are truthful and accurately depict the property's condition and features without creating misleading impressions. Correct answer is D. Ensuring all visual representations are truthful and accurately depict the property's condition and features without creating misleading impressions. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate salesperson in British Columbia because it involves balancing the desire to create compelling marketing materials with the legal and ethical obligations to accurately represent a property. Misleading photography or videography can lead to misrepresentation, breach of contract, and damage to the salesperson's reputation and the brokerage standing. The salesperson must exercise careful judgment to ensure all visual content is truthful and not deceptive, adhering to the Real Estate Services Act (RESA) and the Real Estate Council of British Columbia's (REC) rules. Correct approach analysis. The best professional practice involves capturing and presenting the property in a way that is truthful and accurate, avoiding any enhancements that create a false impression. This means using natural lighting where possible, ensuring all visible features are accurately depicted, and not digitally altering the property to appear larger, cleaner, or more appealing than it is in reality. This approach aligns with the REC rules, particularly those concerning advertising and representation, which mandate that licensees must not make false or misleading statements or representations. The intent is to provide potential buyers with a realistic preview of the property, enabling them to make informed decisions. Incorrect approaches analysis. Presenting a digitally enhanced video that makes a small backyard appear significantly larger than it is in reality is ethically and legally problematic. This constitutes a misleading representation, violating the salesperson's duty of honesty and integrity under RESA and REC rules. Such an action could lead to a complaint to the REC, disciplinary action, and potential legal recourse from the buyer. Using drone footage that exclusively focuses on the property's best angles while omitting any visible neighboring structures or potential nuisances, such as a busy road, is also a failure to provide a complete and accurate picture. While showcasing positive attributes is acceptable, deliberately omitting significant contextual information that could influence a buyer's decision is misleading. This contravenes the principle of full disclosure and fair representation, including professional staging and lighting to make an outdated kitchen appear modern and updated, without any disclosure of the actual condition or the need for renovations, is another form of misrepresentation. While staging is a common practice, the visual presentation must not create a false impression of the property's inherent features or condition. This misleads potential buyers about the property's true state. Professional reasoning. Professionals should always prioritize accuracy and transparency in all marketing materials. The decision-making process should involve asking, does this visual representation accurately reflect the property as it is, or could it lead a potential buyer to form an incorrect impression? If there is any doubt, it is better to err on the side of caution and provide a more conservative, truthful depiction. Always consider the REC rules on advertising and representation, and the overarching duty to act with honesty and integrity. When in doubt, consult with the brokerage's managing broker or the REC for guidance. Question 2. The performance metrics show that a property in Vancouver, British Columbia, featuring a custom-built wine cellar and a professional-grade home theater, has attracted significant interest from potential buyers. As the listing salesperson, you are tasked with providing an accurate valuation to your client. Considering the unique, high-end amenities of this residential property, which valuation method, when applied with appropriate adjustments, best reflects its current market value and aligns with professional standards in British Columbia? Option A. An income approach valuation that estimates the potential rental income these luxury features could generate, using market rental rates for similar amenities. Option B. a hybrid approach that averages the results of an income approach and a cost approach, assuming these two methods will provide a balanced perspective. Option C, a meticulously adjusted comparative market analysis, CMA, that incorporates detailed adjustments for the unique amenities and condition relative to comparable sold properties in the neighborhood. Option D, a cost approach valuation that calculates the current cost to build a similar property, factoring in depreciation for the existing structure and its unique features. The correct answer is C, a meticulously adjusted comparative market analysis, CMA, that incorporates detailed adjustments for the unique amenities and condition relative to comparable sold properties in the neighborhood. Explanation: this scenario presents a professional challenge because a real estate salesperson in British Columbia must select the most appropriate valuation method for a unique property, balancing the needs of the client with regulatory requirements and ethical obligations. The salesperson must demonstrate a thorough understanding of different valuation approaches and their applicability, ensuring the advice provided is accurate, defensible, and compliant with the Real Estate Services Act, RESA, and its associated rules. The challenge lies in moving beyond a superficial understanding to a deep, context-specific application of valuation principles. The most appropriate approach in this scenario involves a comprehensive comparative market analysis, CMA, that is meticulously adjusted for the property's unique features. This method is correct because it directly addresses the core principle of market value by comparing the subject property to similar, recently sold properties in the immediate vicinity. For a property with significant, non-standard upgrades like a custom-built wine cellar and a professional-grade home theater, a CMA is best suited as it allows for direct comparison and adjustment. The salesperson must demonstrate due diligence by identifying comparable sales and making objective, well-supported adjustments for the differences, such as the unique amenities, condition, and location. This aligns with the ethical duty under RESA to act with integrity and competence, providing clients with advice that is informed by current market conditions and the specific characteristics of the property. Furthermore, the Real Estate Council of British Columbia, RECO, emphasizes the importance of accurate property valuations as a cornerstone of professional practice. Using only the income approach would be professionally unacceptable. While the income approach is valuable for income-generating properties like apartment buildings or commercial spaces, it is not the primary or most reliable method for a single-family residential property, even one with luxury features. Applying it without significant justification would fail to reflect the true market value driven by owner-occupier demand, and would likely lead to an inaccurate valuation. This could be considered a failure to act competently and in the best interests of the client, potentially violating RESA. Relying solely on the cost approach would also be professionally unacceptable. The cost approach, which estimates the cost to replace or reproduce the property, is generally most effective for newer construction or unique properties where comparable sales are scarce. However, for a property with a history and existing market, it often overestimates value by not adequately accounting for depreciation, physical, functional, or external obsolescence, or by failing to capture market sentiment and demand. Applying it without considering market comparables would disregard the fundamental principle of market value and could mislead the client, breaching ethical obligations under RESA. The professional decision-making process should involve a systematic evaluation of the property's type, purpose of the valuation, and the availability of reliable data. The salesperson should first consider the most common and market-driven valuation method for the property type. In British Columbia, for residential properties, this is typically a CMA. The salesperson must then critically assess whether the unique features of the property necessitate modifications or supplementary use of other approaches. For instance, if the unique features significantly impact potential rental income, the income approach might be used as a secondary check, but not as the sole determinant of value for a residential sale. Similarly, if the property is highly specialized and comparables are extremely difficult to find, the cost approach might be considered, but its limitations regarding depreciation and market appeal must be thoroughly addressed. Ultimately, the salesperson's duty is to provide a valuation that is both accurate and defensible, grounded in market realities and compliant with provincial regulations. Question 3. System analysis indicates that a real estate salesperson in British Columbia, while representing a seller, learns that a close personal friend is interested in purchasing the property. What is the most appropriate and ethically sound course of action for the salesperson to take? Option A. Immediately disclose the personal relationship with the potential buyer to the seller client and seek their informed consent on how to proceed. Option B. Advise the potential buyer to offer a lower price, leveraging their knowledge of the seller's circumstances, without disclosing this to the seller. Option C. Proceed with the sale negotiations without informing the seller about the personal relationship with the buyer, assuming it will not affect their professional judgment. Option D. Focus on facilitating the sale to earn a commission, downplaying the personal connection to the buyer to avoid complicating the transaction. The correct answer is A. Immediately disclose the personal relationship with the potential buyer to the seller client and seek their informed consent on how to proceed. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the salesperson to navigate a potential conflict of interest while upholding their fiduciary duties to their client. The salesperson's personal relationship with the potential buyer could influence their advice and action, potentially compromising the best interests of their seller client. Careful judgment is required to ensure transparency, fairness, and adherence to professional standards and the Real Estate Services Act of British Columbia. Correct approach analysis. The best professional practice involves immediately disclosing the personal relationship with the potential buyer to the seller client. This approach is correct because it prioritizes transparency and informed consent, which are fundamental ethical and regulatory obligations for real estate professionals in British Columbia. By disclosing the relationship, the salesperson allows the seller to make an informed decision about how to proceed, potentially including continuing with the salesperson or seeking alternative representation. This aligns with the duty of loyalty and the obligation to act in the best interests of the client, as stipulated by the Real Estate Services Act and the Real Estate Services Regulation. Incorrect approaches analysis. Proceeding with the sale without informing the seller about the personal relationship with the buyer is an ethical failure. It breaches the duty of loyalty and good faith owed to the seller client, as it creates a hidden conflict of interest. This action could lead to the seller feeling misled or that their interests were not fully represented, potentially resulting in a complaint to the Real Estate Council of British Columbia. Suggesting to the buyer that they offer a lower price based on the salesperson's personal knowledge of the seller's situation, without full disclosure to the seller, is a severe ethical and regulatory breach. This action directly undermines the seller's position and exploits the confidential information gained through the agency relationship for the benefit of a third party, the buyer, and potentially the salesperson, violating the duty to act in the best interests of the seller. Focusing solely on securing the sale to earn a commission, while downplaying or ignoring the personal relationship with the buyer, demonstrates a disregard for the seller's best interests and a failure to manage a conflict of interest appropriately. This prioritizes personal gain over professional obligation and could lead to accusations of misrepresentation or negligence. Professional reasoning. Professionals should employ a conflict of interest management framework. This involves identifying potential conflicts, assessing their severity, disclosing them transparently to all affected parties, and seeking informed consent. If a conflict cannot be managed effectively through disclosure and consent, the professional should withdraw from representing one or more parties to avoid compromising their duties. In this situation, immediate and full disclosure to the seller is the paramount first step. Question 4. System analysis indicates that a prospective buyer in British Columbia has obtained a mortgage pre-approval letter for a property they are interested in purchasing. As their real estate salesperson, what is the most responsible and ethically sound approach to discussing this pre-approval with the buyer? Option A. Inform the buyer that they have secured their financing and can proceed with making an offer, as the pre-approval letter signifies a confirmed loan amount. Option B. Tell the buyer to disregard the conditions and stipulations mentioned in the pre-approval letter, as the lender has already committed to the loan. Option C. Clearly explain that mortgage pre-approval is not a guarantee of financing and outline the subsequent steps required for a firm mortgage commitment, including lender underwriting and property appraisal. Option D. Advise the buyer that the pre-approval letter means their financing is essentially in place, and they should focus on other aspects of the purchase. The correct answer is C. Clearly explain that mortgage pre-approval is not a guarantee of financing and outline the subsequent steps required for a firm mortgage commitment, including lender underwriting and property appraisal. Explanation. Scenario analysis. This scenario presents a professional challenge for a British Columbia real estate salesperson because it requires navigating the complexities of mortgage pre-approval and its implications for a buyer's ability to complete a purchase. Misunderstanding or misrepresenting the significance of a pre-approval can lead to significant financial and legal repercussions for the buyer and potential professional liability for the salesperson. Careful judgment is required to ensure the buyer fully understands the limitations of pre-approval and the steps necessary for firm financing. Correct approach analysis. The best professional practice involves clearly and comprehensively explaining to the buyer that mortgage pre-approval is not a guarantee of financing. This approach involves educating the buyer on the difference between pre-approval and a firm mortgage commitment, emphasizing that the lender will still conduct a full underwriting process, including property appraisal and verification of all financial details, before approving the final loan. This aligns with the salesperson's duty to act with honesty and integrity, and to provide competent service as outlined in the Real Estate Services Act and its associated rules. Specifically, Section 43 of the Real Estate Services Act mandates that a licensee must not misrepresent facts or opinions to a client, and the rules of the Real Estate Council of British Columbia require licensees to act in the best interest of their clients. Incorrect approaches analysis. One incorrect approach is to present mortgage pre-approval as equivalent to a guaranteed loan. This is a misrepresentation of fact and fails to uphold the salesperson's duty of honesty and integrity. It can lead the buyer to believe they have secured financing when they have not, potentially causing them to enter into a purchase agreement they cannot fulfill, which is a violation of professional conduct. Another incorrect approach is to simply state that the buyer has financing in place, based solely on the pre-approval letter without further clarification. This is an oversimplification that omits crucial information about the conditional nature of pre-approval. It fails to provide the buyer with the full picture necessary for informed decision-making, thereby not acting in the client's best interest and potentially breaching the duty of care. A third incorrect approach is to advise the buyer to rely solely on the pre-approval letter and not to seek further advice from their mortgage broker or lender regarding the conditions of the loan. This is detrimental to the buyer's financial well-being and demonstrates a lack of diligence on the part of the salesperson. It suggests a failure to ensure the client is fully informed about all aspects of their financing, which is a core ethical obligation. Professional reasoning. Professionals should adopt a proactive and educational approach. When dealing with mortgage pre-approvals, the decision-making process should involve 1. Understanding the client's financial situation and their understanding of financing terms. 2. Clearly explaining the nature and limitations of mortgage pre-approval, distinguishing it from a firm commitment. 3. Advising the client to maintain open communication with their mortgage broker or lender to understand all conditions and requirements. 4. Ensuring the client understands that the purchase agreement will likely be subject to a financing condition that must be satisfied by a firm mortgage commitment. This systematic approach ensures transparency, protects the client, and upholds professional standards. Question 5. The assessment process reveals that a property located in the Fraser Valley, British Columbia, has a large parcel of land with significant agricultural zoning, but also includes a substantial, well-maintained farmhouse and several outbuildings that could be renovated for residential or commercial purposes. The seller expresses a strong desire to market the property primarily as a potential rural residential estate, emphasizing the lifestyle aspects of the farmhouse and grounds. What is the most appropriate course of action for the real estate salesperson to take? Option A. Market the property solely based on its agricultural zoning, emphasizing its suitability for farming operations, and only mentioning the farmhouse as a secondary feature for farm workers. Option B. Advise the seller that the property can only be marketed as agricultural land due to its zoning, and refuse to market it as a rural residential estate, regardless of the seller's wishes or the farmhouse's condition. Option C. Market the property by highlighting its potential for rural residential living, while also clearly disclosing the existing agricultural zoning and the seller's primary intention to sell for that purpose, and advising potential buyers to conduct their own due diligence regarding any alternative uses. Option D. Market the property exclusively as a rural residential estate, focusing on the farmhouse and grounds, and downplaying or omitting the agricultural zoning to appeal to buyers seeking a lifestyle property. The correct answer is C. Market the property by highlighting its potential for rural residential living, while also clearly disclosing the existing agricultural zoning and the seller's primary intention to sell for that purpose, and advising potential buyers to conduct their own due diligence regarding any alternative uses. Explanation: this scenario is professionally challenging because it requires the salesperson to accurately identify the primary intended use of a property, which dictates the applicable regulations, marketing strategies, and potential buyer pool. Misclassifying the property can lead to significant legal and ethical breaches, including misrepresentation, failure to disclose material facts, and potential financial damages for the client. Careful judgment is required to distinguish between the dominant characteristics of the property and secondary or potential uses. Best professional approach involves a thorough assessment of the property's current use, zoning regulations in British Columbia, and the seller's stated intentions, while also considering the physical characteristics of the land and any existing structures. This comprehensive evaluation ensures the property is marketed accurately and in compliance with the Real Estate Services Act, RESA, and its associated rules, particularly those pertaining to professional conduct and disclosure. By focusing on the dominant use and verifying it against official records and the property's physical attributes, the salesperson upholds their duty of care and avoids misleading potential buyers. An incorrect approach would be to solely rely on the seller's verbal assertion of a potential future use without verifying it against zoning or the property's current physical state. This fails to meet the professional standard of due diligence and could lead to misrepresentation if the intended future use is not legally permissible or practically feasible. Another incorrect approach is to market the property based on a secondary or minor feature without acknowledging the primary use, which can mislead buyers about the property's true nature and limitations. For instance, marketing a predominantly agricultural property with a small residential dwelling solely as a residential property ignores its agricultural zoning and potential, thereby failing to attract the appropriate buyer and potentially violating RESA disclosure requirements. Professionals should employ a decision-making framework that prioritizes verification and accuracy. This involves 1. Understanding the client's objectives. 2. Conducting independent research into zoning and land use bylaws specific to the British Columbia municipality. 3. Physically inspecting the property to assess its dominant characteristics and existing structures. 4. Consulting with relevant authorities if zoning or intended use is unclear. 5. Clearly documenting all findings and discussions. This systematic process ensures that the property is classified and marketed correctly, protecting both the client and the public interest. Question 6. The monitoring system demonstrates that a buyer client, for whom you are the listing agent in British Columbia, has indicated that their mortgage pre-approval may not be sufficient to secure the final financing for the property they have agreed to purchase, and the financing condition is still active. What is the most appropriate immediate course of action for the salesperson? Option A. Advise the buyer to immediately consult with their mortgage broker and a real estate lawyer to fully understand their financing options and the implications of the financing condition. Option B. Advise the buyer to simply wait until the financing condition deadline passes and hope the lender approves the mortgage. Option C. Recommend the buyer withdraw their offer immediately to avoid potential complications, regardless of the contractual implications. Option D. Suggest the buyer attempt to renegotiate the purchase price with the seller, citing general market conditions, without disclosing the specific financing concerns. The correct answer is A. Advise the buyer to immediately consult with their mortgage broker and a real estate lawyer to fully understand their financing options and the implications of the financing condition. Explanation: this scenario presents a professional challenge because it requires a real estate salesperson in British Columbia to navigate a situation where a buyer's financing is uncertain, potentially jeopardizing the transaction and impacting both the buyer and seller. The salesperson must act ethically and in accordance with the Real Estate Services Act RESA and its associated rules, as well as the policies of the Real Estate Council of British Columbia. The core of the challenge lies in balancing the salesperson's duty to their client, the buyer, with the need for transparency and adherence to contractual obligations. The best approach involves immediately advising the buyer to seek professional legal and financial advice, to understand the implications of their financing situation, and to explore all available options for fulfilling the contract or mitigating potential losses. This is correct because it prioritizes the buyer's best interests by empowering them with expert guidance. It aligns with the salesperson's fiduciary duty to act with reasonable care and skill, and to avoid conduct that would bring the profession into disrepute. Specifically, RSA and the rules mandate that licensees act honestly and with integrity, and this includes ensuring clients are fully informed and supported when facing complex contractual issues like financing. Facilitating access to legal and financial experts is a key part of fulfilling this duty. An incorrect approach would be to advise the buyer to simply ignore the financing condition and hope for the best. This is professionally unacceptable because it fails to address the contractual obligation and the potential legal ramifications for the buyer. It demonstrates a lack of due diligence and could lead to a breach of contract, exposing the buyer to legal action and financial penalties. This conduct would violate the salesperson's duty to act competently and to avoid misrepresentation or misleading the client. Another incorrect approach would be to suggest the buyer try to renegotiate the purchase price with the seller without fully disclosing the underlying financing issue. While renegotiation might be a possible outcome, doing so without transparency about the reason for the renegotiation is unethical. It could be seen as a form of misrepresentation or bad faith bargaining, potentially harming the seller's trust and violating the salesperson's obligation to be honest and fair in all dealings. Finally, advising the buyer to withdraw from the contract without exploring all avenues or understanding the legal consequences of such a withdrawal would also be an incorrect approach. This could lead to the buyer forfeiting their deposit or facing other penalties, and it fails to provide the buyer with the comprehensive advice needed to make an informed decision. The salesperson's role is to facilitate informed decision-making, not to dictate actions that may not be in the buyer's best long-term interest or legally sound. The professional decision-making process for similar situations should involve 1. Identifying the core issue: uncertain financing. 2. Recognizing the salesperson's duties under RSA and the rules: honesty, integrity, competence, client best interests. 3. Prioritizing client well-being by recommending expert advice, legal and financial. 4. Ensuring transparency and adherence to contractual obligations. 5. Avoiding actions that could be construed as misrepresentation or unethical conduct. Question 7. Benchmark analysis indicates that a property listed for sale in Surrey, British Columbia, is situated in an area with a history of light industrial activity and is adjacent to a former manufacturing plant. The seller has expressed no knowledge of any environmental contamination. As a real estate salesperson representing the seller, what is the most prudent risk assessment approach to ensure your client is fully informed and protected? Option A. Downplay the potential environmental risks due to the property's history, focusing solely on its market appeal and current condition to expedite the sale. Option B. Advise the seller that given the property's location and history, a Phase I environmental site assessment by a qualified professional is a recommended step to identify potential environmental liabilities and discuss the implications of its findings with them. Option C. Assure the seller that since they have no knowledge of contamination, the property is likely clear, and proceed with marketing and selling the property without further investigation. Option D. Inform the seller that environmental assessments are complex and costly, and it is solely the buyer's responsibility to conduct any due diligence regarding environmental concerns. Correct answer is B. Advise the seller that given the property's location and history, a Phase I environmental site assessment by a qualified professional is a recommended step to identify potential environmental liabilities and discuss the implications of its findings with them. Explanation: this scenario is professionally challenging because it requires a real estate salesperson in British Columbia to navigate potential environmental liabilities that could significantly impact a property's value and the client's financial well-being. A failure to adequately assess and disclose these risks can lead to legal repercussions, loss of trust, and damage to the salesperson's reputation, all while potentially contravening the Real Estate Services Act, RSA, and its associated rules. The best professional approach involves proactively identifying potential environmental concerns and recommending a thorough, independent assessment. This aligns with the salesperson's duty of care to their client and their obligation under RSA to act with honesty and integrity. Specifically, the salesperson should advise the client that given the property's history and proximity to industrial activity, a Phase I environmental site assessment, ESSA, is a prudent step. This assessment, conducted by qualified environmental professionals, would identify potential or existing environmental contamination without intrusive sampling. The findings would then inform the client about potential remediation costs, disclosure obligations to future buyers, and any associated risks, enabling informed decision-making. This proactive stance demonstrates due diligence and upholds the highest ethical standards by prioritizing the client's informed consent and protection from unforeseen liabilities. An incorrect approach would be to dismiss the client's concerns or downplay the potential environmental risks based on a superficial understanding of the property's history. This fails to meet the duty of care and could lead to the client incurring significant unexpected costs or facing legal challenges if contamination is later discovered. It also breaches the obligation to provide competent service and act in the client's best interest. Another incorrect approach is to proceed with the sale without any further investigation, assuming the property is free of environmental issues simply because no obvious signs of contamination are present. This ignores the potential for hidden contamination, which is common in areas with historical industrial use. Such an oversight could result in the client unknowingly selling a contaminated property, leading to future liability and potential lawsuits from the buyer. This demonstrates a lack of due diligence and a failure to protect the client from potential harm. Finally, an incorrect approach would be to suggest that the salesperson's role is limited to facilitating the transaction, and that environmental assessments are solely the buyer's responsibility. While the ultimate decision to conduct an assessment rests with the client, the salesperson has a professional obligation to advise on potential risks and recommend appropriate steps to mitigate them, especially when red flags are present. Failing to do so abdicates responsibility and can be seen as a dereliction of professional duty. Professionals should adopt a risk-based decision-making process. When presented with information suggesting potential environmental concerns, the first step is to acknowledge and validate these concerns. Next, the salesperson must assess the potential impact on the client and the transaction. This involves considering the property's history, surrounding land use, and any visible indicators. Based on this assessment, the salesperson should then recommend appropriate actions, such as engaging qualified professionals for specialized assessments, to gather more definitive information. Transparency and clear communication with the client throughout this process are paramount, ensuring they understand the risks and the recommended steps to address them. Question 8. Benchmark analysis indicates that a buyer in British Columbia, represented by a salesperson, has expressed confusion regarding the interpretation of a specific clause in a signed contract of purchase and sale concerning the inclusion of certain fixtures. The salesperson believes they understand the buyer's intent, but the clause is indeed ambiguous and could be interpreted in multiple ways, potentially impacting the final sale price and the items the buyer will receive. What is the most appropriate course of action for the salesperson to take in this situation? Option A. Immediately contact both the buyer and the seller to discuss the ambiguous clause, explain the potential interpretations, and propose drafting a formal addendum to clarify the term to the mutual satisfaction of both parties before proceeding. Option B. Proceed with the sale based on the salesperson's understanding of the buyer's intent, assuming the buyer will raise any further concerns during the final walkthrough. Option C. Advise the buyer that the clause is likely insignificant and can be disregarded, as the salesperson believes it does not materially affect the transaction. Option D. Recommend that the buyer immediately withdraw from the contract of purchase and sale due to the ambiguity, without attempting to clarify or amend the clause. The correct answer is A. Immediately contact both the buyer and the seller to discuss the ambiguous clause, explain the potential interpretations, and propose drafting a formal addendum to clarify the term to the mutual satisfaction of both parties before proceeding. Explanation. This scenario presents a professional challenge because it involves a potential breach of contract due to a misunderstanding of a key term, which could lead to legal disputes and financial repercussions for both the buyer and the seller. A real estate salesperson must navigate this situation with utmost care, ensuring adherence to the terms of the contract and the principles of fair dealing as mandated by British Columbia's real estate legislation and professional standards. The best approach involves seeking clarification and proposing a formal amendment to the contract. This demonstrates a commitment to upholding the integrity of the agreement and protecting the interests of all parties involved. By proactively addressing the ambiguity and seeking a mutually agreeable solution through a written addendum, The salesperson ensures that the contract accurately reflects the parties' intentions. This aligns with the regulatory requirement in British Columbia to act with honesty and integrity, and to ensure that all agreements are clear and enforceable. The Real Estate Services Act, RESA, and its associated rules require licensees to act in the best interests of their clients and to avoid misrepresentation or misleading conduct. An incorrect approach would be to proceed with the sale based on the salesperson's assumption of the term's meaning without confirming with the buyer. This carries a significant risk of misrepresentation and breach of contract. The salesperson is obligated to ensure the client fully understands all terms and conditions, and proceeding without confirmation violates the duty of care and the requirement for informed consent. Another incorrect approach would be to advise the buyer to simply ignore the clause, assuming it is not important. This is a direct contravention of the salesperson's duty to uphold the contractual agreement and could expose both the buyer and the salesperson to legal action for breach of contract and professional misconduct. The salesperson cannot unilaterally decide which contractual terms are unimportant or unenforceable. Finally, advising the buyer to withdraw from the contract without attempting to resolve the ambiguity is also professionally unsound. While withdrawal might be a last resort, it should only be considered after all reasonable attempts to clarify and amend the contract have been exhausted. This approach fails to explore solutions that could preserve the transaction and meet the client's objectives, potentially breaching the duty to act in the client's best interests. Professionals should employ a decision-making framework that prioritizes clear communication, thorough understanding of contractual terms, and adherence to legal and ethical obligations. This involves actively seeking clarification when ambiguity arises, documenting all discussions and agreements, and ensuring that any modifications to a contract are made through formal, written amendments that are understood and agreed upon by all parties. Question 9. The evaluation methodology shows that a real estate salesperson in British Columbia is representing a landlord who wishes to renew a tenant's lease agreement, which is set to expire in 2 months. The landlord wants to increase the rent by 10% and has instructed the salesperson to prepare a new lease agreement reflecting these terms and have the tenant sign it immediately to secure the renewal. The tenant has been a long-term resident and has always paid rent on time. What is the most appropriate course of action for the salesperson? Option A. Inform the tenant that the landlord is increasing the rent by 10% and that they must sign the new lease agreement within a week to avoid the landlord seeking new tenants. Option B. Advise the landlord on the proper notice periods and forms required under the Residential Tenancy Act of British Columbia for proposing a rent increase and lease renewal, and assist in preparing the legally compliant documentation for the tenant. Option C. Immediately prepare a new lease agreement with the landlord's proposed 10% rent increase and present it to the tenant for signature, emphasizing the urgency of securing the renewal. Option D. Advise the landlord to allow the current lease to expire and then offer the tenant a new lease at the increased rate, suggesting this is a simpler way to achieve the desired outcome. The correct answer is B. Advise the landlord on the proper notice periods and forms required under the Residential Tenancy Act of British Columbia for proposing a rent increase and lease renewal, and assist in preparing the legally compliant documentation for the tenant. Explanation. This scenario presents a professional challenge because it requires a real estate salesperson in British Columbia to navigate a conflict between a landlord's immediate desire for a lease renewal and the tenant's right to receive proper notice and consider their options. The salesperson must balance their duty to their client, the landlord, with their ethical obligations and the legal requirements of the Residential Tenancy Act (RTA) of British Columbia. Careful judgment is required to ensure all parties are treated fairly and legally. The best professional approach involves prioritizing legal compliance and tenant rights. This means ensuring the landlord understands the statutory notice periods required under the RTA for ending a tenancy or proposing changes to a lease. The salesperson should advise the landlord that they cannot unilaterally dictate a new lease term or rent increase without adhering to these notice requirements. Instead, they should guide the landlord through the proper channels for proposing a renewal or rent increase, which includes providing the tenant with the legally mandated notice period and form, e.g., a notice of rent increase or a tenancy agreement addendum for renewal. This approach upholds the RTA, protects the tenant's rights to adequate notice and the opportunity to respond, and maintains the salesperson's professional integrity. An incorrect approach would be to immediately prepare a new lease agreement with the landlord's proposed terms and present it to the tenant for signature, without regard for the existing lease's expiry date or the RTA's notice provisions. This fails to acknowledge the tenant's rights under the current agreement and bypasses the legal framework for lease renewals and rent adjustments, potentially leading to disputes and legal challenges. Another incorrect approach would be to pressure the tenant into signing the new lease agreement quickly to secure the landlord's desired rent increase, implying that failure to sign would result in eviction or other negative consequences. This constitutes undue influence and disregards the tenant's right to consider the proposed terms within the legally defined timeframe. It also misrepresents the landlord's obligations under the RTA. Finally, an incorrect approach would be to advise the landlord to simply let the current lease expire and then attempt to re-rent the property at a higher rate without proper notice or consideration of the tenant's rights as a sitting tenant. This circumvents the RTA's provisions regarding lease renewals and rent increases for existing tenancies and could be interpreted as an attempt to illegally end a tenancy. Professionals should employ a decision-making framework that begins with identifying the governing legislation, in this case, the RTA of British Columbia. They must then understand the rights and obligations of all parties involved. Ethical considerations, such as fairness and honesty, should be integrated with legal requirements. When faced with a client's request that may conflict with legal or ethical obligations, the professional's duty is to educate the client on the correct procedures and advise them accordingly, even if it means not immediately fulfilling the client's initial request. Question 10. The evaluation methodology shows a property in Vancouver, British Columbia, with a gross annual rental income of $48,000 and annual operating expenses, property taxes, insurance, maintenance, etc. of $12,000. The asking price for the property is $600,000. If a potential investor is considering this property as part of a diversified portfolio, which of the following analytical approaches best represents a sound initial assessment of its investment potential, considering the regulatory framework for real estate professionals in British Columbia? Option A. Estimate the potential annual appreciation of the property and divide it by the purchase price to assess the investment's growth potential. Option B. Calculate the return based solely on the gross rental income, dividing it by the property's value to determine a gross yield. Option C. Calculate the net operating income (NOI) by subtracting operating expenses from gross rental income, and then determine the capitalization rate (cap rate) by dividing the NOI by the property's value. Option D. Calculate the annual cash flow by subtracting mortgage payments from the NOI, and then divide this cash flow by the initial down payment to determine the cash-on-cash return, ignoring the total property value. The correct answer is C. Calculate the net operating income (NOI) by subtracting operating expenses from gross rental income, and then determine the capitalization rate (cap rate) by dividing the NOI by the property's value. Explanation. The evaluation methodology shows a common challenge for real estate salespeople in British Columbia, accurately assessing investment potential for clients while adhering to professional standards and regulatory requirements. This scenario is professionally challenging because it requires not only mathematical proficiency, but also an understanding of how different financial metrics can be presented and interpreted, potentially influencing a client's decision. A salesperson must ensure the analysis provided is comprehensive, transparent, and ethically sound, avoiding any misleading representations. The Real Estate Services Act, RESA, and its associated rules require licensees to act with honesty and integrity, and to provide competent service. This includes ensuring that any advice or analysis provided is accurate and not misleading. The best approach involves calculating the net operating income, NOI, and then using it to determine the capitalization rate, cap rate. This method is correct because it directly reflects the property's income-generating potential relative to its market value, a fundamental metric for real estate investors. The cap rate provides a standardized way to compare the profitability of different investment properties. Specifically, NOI is calculated by subtracting all operating expenses from the gross rental income. The formula for cap rate is \text cap rate equals \frac text net operating income text property value times 100 %. This approach aligns with the professional obligation to provide clients with objective, data-driven analysis that facilitates informed investment decisions. As mandated by RISA and the ethical guidelines of the Real Estate Council of British Columbia, an approach that focuses solely on gross rental income without accounting for operating expenses is incorrect. This is because it presents an inflated picture of profitability, failing to acknowledge the costs associated with owning and managing a property. Such an omission would be misleading and could lead a client to overestimate the potential return on investment, violating the duty of care and honesty. Another incorrect approach is to calculate the return based only on the initial down payment and annual cash flow, without considering the total property value. While cash-on-cash return is a useful metric, presenting it in isolation without the context of the cap rate or other property-level metrics can be incomplete. Furthermore, if this calculation is presented as the sole indicator of investment performance, it could be misleading, as it doesn't reflect the overall efficiency of the property's operations relative to its acquisition cost. Finally, an approach that relies on comparing the property's potential appreciation to its purchase price without considering income generation is also flawed for investment analysis. While appreciation is a component of total return, focusing solely on it ignores the income-producing aspect of real estate, which is often a primary driver for investors. This incomplete analysis fails to provide a holistic view of the investment's performance and could lead to poor decision-making. Professionals should adopt a decision-making framework that prioritizes a comprehensive and transparent analysis. This involves 1. Understanding the client's investment goals. 2. Identifying all relevant financial data, including income and expenses. 3. Applying appropriate analytical tools, such as NOI and cap rate calculations, to assess profitability and compare investment opportunities. 4. Presenting the analysis clearly and honestly, explaining the meaning and limitations of each metric. 5. Ensuring all advice and representations comply with RISA and the rules. Question 11. The control framework reveals that a real estate salesperson in British Columbia is representing a seller whose property has been on the market for longer than anticipated. The seller expresses concern that the local real estate market may be entering a downturn, impacting their ability to achieve their desired sale price. Which of the following approaches best demonstrates professional judgment and adherence to regulatory obligations? Option A. Reassure the seller that market fluctuations are normal and that their concerns are likely unfounded, encouraging them to maintain the current listing price and wait for a buyer. Option B. Rely on past successful sales in the area from several months ago as the primary basis for advising the seller on pricing and market expectations, without further current market analysis. Option C. Advise the seller to immediately reduce the listing price significantly to attract any potential buyer quickly, prioritizing a swift sale over achieving the optimal market price. Option D. Conduct thorough research into current and projected real estate cycles and trends specific to the British Columbia market where the property is located, and use this data to advise the seller on realistic pricing, marketing adjustments, and negotiation strategies. The correct answer is D. Conduct thorough research into current and projected real estate cycles and trends specific to the British Columbia market where the property is located, and use this data to advise the seller on realistic pricing, marketing adjustments, and negotiation strategies. Explanation. The control framework reveals that real estate markets, including those in British Columbia, are subject to cyclical fluctuations and evolving trends. This scenario is professionally challenging because a real estate salesperson must navigate these market dynamics while upholding their fiduciary duties to clients and adhering to the Real Estate Services Act, RISA, and its associated rules. Misinterpreting or ignoring market trends can lead to poor advice, financial detriment for clients, and potential breaches of professional conduct. The best approach involves proactively researching and understanding current and projected real estate cycles and trends in the specific British Columbia market. This includes analyzing economic indicators, demographic shifts, local development plans, and historical market data relevant to the property's location and type. A salesperson employing this approach would then use this informed understanding to provide realistic advice to their client regarding pricing, marketing strategies, and negotiation tactics. This aligns with the ethical obligation under RISA to act with reasonable skill and care, and to provide competent service, It also supports the duty to act in the client's best interest by ensuring decisions are based on sound market knowledge, not speculation or personal bias. An incorrect approach would be to dismiss the client's concerns about a potential market downturn as mere anxiety. This fails to acknowledge the salesperson's responsibility to provide informed advice and could lead to the client making a decision that is not in their best financial interest, potentially violating the duty of care. Another incorrect approach is to solely focus on short-term gains by pushing for a quick sale at any price, regardless of market conditions or the client's long-term goals. This prioritizes the salesperson's commission over the client's welfare and contravenes the fiduciary duty to act in the client's best interest. A further incorrect approach is to rely on outdated market information or anecdotal evidence without conducting thorough, current research. This demonstrates a lack of due diligence and competence, which is a failure to meet the standards expected under RISA. Professionals should employ a decision-making process that begins with active listening to the client's concerns, followed by diligent research into relevant market data and trends. This research should inform a balanced discussion with the client, presenting realistic expectations and strategic options. The ultimate decision should be a collaborative one, grounded in objective market analysis and the client's specific objectives, always within the bounds of regulatory requirements and ethical obligations. Question 12. Cost-benefit analysis shows that a thorough tenant screening process is crucial for landlords in British Columbia to mitigate risks. A real estate salesperson is assisting a landlord in finding a new tenant. Which of the following screening practices best aligns with the legal and ethical obligations of a real estate professional in British Columbia? Option A. Inquiring about the prospective tenant's plans for starting a family and their current marital status to gauge their long-term commitment to the tenancy. Option B. Rejecting an applicant solely because they receive income from social assistance programs, regardless of their other qualifications. Option C. Requesting detailed information about the prospective tenant's medical history and any past illnesses to ensure they will not cause damage to the property. Option D. Verifying employment and income, checking references from previous landlords, and reviewing credit reports to assess the prospective tenant's financial stability and tenancy history. The correct answer is D. Verifying employment and income, checking references from previous landlords, and reviewing credit reports to assess the prospective tenant's financial stability and tenancy history. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate salesperson in British Columbia because tenant screening involves balancing the landlord's legitimate need to select a reliable tenant with the tenant's right to privacy and protection from discrimination. Missteps in this process can lead to legal liability for the salesperson and the landlord, as well as damage to professional reputation. The salesperson must navigate the requirements of the Residential Tenancy Act (RTA) and the Human Rights Code of British Columbia, ensuring that screening practices are fair, consistent, and non-discriminatory. Correct approach analysis. The best professional practice involves developing a standardized screening process that focuses on objective criteria directly related to a prospective tenant's ability to fulfill the lease obligations. This includes verifying employment and income, checking references from previous landlords, and reviewing credit reports. These steps are permissible under British Columbia law as they directly assess a candidate's financial stability and history as a tenant. The RTA permits landlords and their agents to inquire into a tenant's ability to pay rent and their history of tenancy. Crucially, all inquiries must be conducted in a manner that respects the prospective tenant's privacy and avoids any discriminatory questioning or consideration of protected grounds under the Human Rights Code. Incorrect approaches analysis. One incorrect approach involves asking broad questions about a prospective tenant's family plans or marital status. This is a direct violation of the Human Rights Code of British Columbia, which prohibits discrimination based on family status and marital status. Such inquiries are irrelevant to a tenant's ability to pay rent or maintain the property, and can lead to allegations of discrimination. Another unacceptable approach is to reject a prospective tenant solely based on their reliance on social assistance or government benefits. While a landlord can assess a tenant's ability to pay rent, outright rejection based on the source of income, without considering other factors like a stable employment history or a strong reference, can be considered discriminatory under the Human Rights Code, particularly if it disproportionately affects individuals from protected groups. Finally, an incorrect approach is to request detailed medical information or inquire about past illnesses. This is an invasion of privacy and is not a legitimate factor in tenant selection. Such inquiries are irrelevant to a tenant's ability to meet their lease obligations and could expose the salesperson and landlord to legal action for privacy breaches and potential discrimination if the information were used improperly. Professional reasoning. Professionals in British Columbia must adopt a screening process that is both effective for the landlord and compliant with all relevant legislation. This requires a proactive approach. 1. Understand the RTA and the Human Rights Code thoroughly. 2. Develop a standardized application form and interview process that focuses on objective criteria. 3. Train all staff involved in screening on fair housing practices and prohibited grounds of discrimination. 4. Treat all applicants consistently and apply the same criteria to everyone. 5. Document all screening steps and decisions. 6. Seek legal advice if unsure about the legality of a particular screening practice. Question 13. Analysis of an investor-client situation in British Columbia reveals a desire to acquire a property quickly using alternative financing. The investor is considering a hard money loan due to its speed, but is also curious about seller financing as a potentially less expensive option. What is the most appropriate course of action for a licensed real estate salesperson in British Columbia? Option A. Strongly advocate for the hard money loan, highlighting its speed and the potential for a quick return on investment, while downplaying the associated risks. Option B. Agree to the client's request for a hard money loan without further discussion, assuming the client is knowledgeable about real estate investments. Option C. Advise the client that seller financing is always the best option for investors in British Columbia due to lower interest rates. Option D. Facilitate a thorough discussion about the risks and benefits of hard money loans and seller financing, emphasizing the need for the client to obtain independent legal and financial advice for both options. The correct answer is D. Facilitate a thorough discussion about the risks and benefits of hard money loans and seller financing, emphasizing the need for the client to obtain independent legal and financial advice for both options. Explanation. This scenario is professionally challenging because it requires a real estate salesperson in British Columbia to navigate complex financing options for an investor client, while adhering to strict ethical and regulatory obligations. The salesperson must ensure the client fully understands the risks and benefits of each financing method, particularly those that deviate from traditional mortgage financing, and act in the client's best interest. The salesperson's duty of care extends to providing accurate information and ensuring the client makes informed decisions, avoiding any misrepresentation or undue influence. The correct approach involves the salesperson facilitating a discussion where the investor client is thoroughly educated on the nature of hard money loans, including their higher interest rates, shorter terms, and the significant risk of foreclosure if repayment terms are not met. This approach also emphasizes the importance of the client seeking independent legal and financial advice to fully understand the implications of such a loan, and to ensure the loan agreement is structured appropriately and legally sound within British Columbia's real estate regulations. This aligns with the salesperson's fiduciary duty to act with honesty and integrity, ensuring the client is not exposed to unreasonable risks without full comprehension. The Real Estate Services Act, RESA, in British Columbia mandates that licensees must act in the best interests of their clients and provide them with all material information relevant to a transaction. An incorrect approach would be for the salesperson to actively recommend or steer the client towards a hard money loan without a comprehensive discussion of its risks and the client's capacity to repay, especially if the salesperson stands to gain a higher commission from a quicker, albeit riskier, transaction. This could be construed as a failure to act in the client's best interest and a potential breach of RESA. Another incorrect approach would be to present seller financing as a simple alternative without exploring the legal complexities, the need for independent legal advice for both parties, and the potential for disputes arising from the loan agreement, which could violate the duty to provide accurate and complete information. Finally, simply agreeing to the client's request for a hard money loan without ensuring the client has sought independent legal and financial advice, and without fully explaining the associated risks, would be a failure to uphold the salesperson's professional responsibilities and could lead to significant liability. Professionals should approach such situations by prioritizing client education and informed consent. This involves clearly outlining all available financing options, detailing the pros and cons of each, and strongly advising the client to seek independent legal and financial counsel before committing to any non-traditional financing. The salesperson's role is to facilitate the transaction ethically and legally, not to provide financial or legal advice, and to ensure the client's understanding and protection. Question 14. The review process indicates that a real estate brokerage in British Columbia has been inconsistent in its monthly reconciliation of trust account statements with its internal transaction ledgers, leading to minor discrepancies that have not been fully investigated or documented. Which of the following actions best addresses this situation in compliance with British Columbia's financial management and record-keeping regulations? Option A. Advise the salespeople involved to review their personal transaction notes to identify any potential errors and to make adjustments to the ledgers as they see fit. Option B. Immediately initiate a thorough internal audit of all trust account reconciliations and transaction records for the past year, involving the brokerage's accountant, to identify the root cause of the discrepancies and implement corrective measures, documenting all findings and actions taken. Option C. Rely on the brokerage senior administrator to manually cross-reference the most recent trust statement with the latest transaction ledger, without involving an external accountant or formal audit process. Option D. Postpone any formal investigation until the next mandatory audit by the Real Estate Services Board, assuming the discrepancies are minor and unlikely to cause significant issues. The correct answer is B. Immediately initiate a thorough internal audit of all trust account reconciliations and transaction records for the past year, involving the brokerage accountant, to identify the root cause of the discrepancies and implement corrective measures, documenting all findings and actions taken. Explanation. The review process indicates a potential lapse in financial record-keeping practices within a real estate brokerage operating in British Columbia. This scenario is professionally challenging because accurate and timely financial reporting is fundamental to maintaining client trust, ensuring regulatory compliance, and safeguarding the brokerage reputation. A failure in this area can lead to significant legal and financial repercussions, including disciplinary action from the Real Estate Services Regulation. Careful judgment is required to identify and rectify any deficiencies promptly. The best approach involves immediately initiating a comprehensive internal audit of all financial records, including trust account statements, transaction ledgers, and expense reports, for the period under review. This audit should be conducted by a qualified individual, such as the brokerage's accountant or a senior administrator with financial oversight responsibilities, to ensure accuracy and adherence to the Real Estate Services Regulation. The findings should then be documented thoroughly and presented to the managing broker for immediate corrective action and to the Real Estate Services Board if required by regulation. This approach is correct because it directly addresses the identified issue with a systematic and compliant process, ensuring that all financial obligations and reporting requirements under British Columbia law are met. It prioritizes transparency, accuracy, and accountability, which are core ethical and regulatory principles for real estate professionals. An incorrect approach would be to dismiss the review findings as minor or to rely solely on the salesperson's personal notes to reconcile discrepancies. This fails to meet the regulatory requirement for proper record-keeping and financial management as stipulated by the Real Estate Services Regulation, bypasses the need for a formal, verifiable audit trail, and leaves the brokerage vulnerable to further scrutiny and potential penalties. Another incorrect approach would be to delay addressing the findings until the next scheduled audit by the Real Estate Services Board. This demonstrates a lack of proactive compliance and a disregard for the ongoing responsibility to maintain accurate financial records. Such a delay could exacerbate any existing issues and may be viewed as an attempt to conceal potential problems, violating ethical standards and regulatory expectations. Finally, an incorrect approach would be to delegate the reconciliation solely to the salesperson involved without proper oversight or independent verification. While salespeople are responsible for their transactions, the ultimate responsibility for financial record-keeping and reporting lies with the brokerage. This approach neglects the brokerage's duty to supervise and ensure compliance with the Real Estate Services Regulation, potentially leading to systemic errors going unnoticed. Professionals should adopt a decision-making framework that prioritizes regulatory compliance and ethical conduct. When faced with potential financial discrepancies or reporting issues, the first step should always be to acknowledge the concern and initiate a thorough, compliant investigation. This involves understanding the specific requirements of the Real Estate Services Regulation regarding financial management and record-keeping, engaging qualified personnel for audits, and maintaining clear, documented communication throughout the resolution process. Proactive identification and correction of issues are paramount to maintaining professional integrity and avoiding regulatory sanctions. Question 15. Performance analysis shows that a real estate salesperson in British Columbia is assisting a client who is seeking to purchase a home. The client explicitly states, "I'm only interested in properties in neighborhoods where families with young children are common, as I want my children to grow up with peers." How should the salesperson ethically and legally respond to this request under British Columbia's Fair Housing Act? Option A. Decline to work with the client entirely, citing a general inability to meet their specific needs without elaborating on the legal or ethical reasons. Option B. Proceed with showing properties in any neighborhood the client expresses interest in, assuming the client's preference is a matter of personal choice and not a discriminatory housing requirement. Option C. Politely inform the client that the request cannot be accommodated as it may lead to discriminatory practices, and explain that the Fair Housing Act prohibits discrimination based on family status and other protected grounds. Option D. Agree to the client's request and focus showings on neighborhoods that appear to have a high concentration of families with children, without directly addressing the discriminatory implications of the request. The correct answer is C. Politely inform the client that the request cannot be accommodated as it may lead to discriminatory practices, and explain that the Fair Housing Act prohibits discrimination based on family status and other protected grounds. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate salesperson in British Columbia to navigate a situation where a potential client's request, while seemingly innocuous, could inadvertently lead to discriminatory practices. The salesperson must balance their duty to serve clients with their absolute obligation to uphold fair housing laws. Failure to do so can result in significant legal penalties, damage to reputation, and harm to individuals seeking housing. Careful judgment is required to identify and mitigate potential discrimination without alienating clients unnecessarily. Correct approach analysis. The best professional practice involves politely but firmly explaining to the client that the request cannot be accommodated due to British Columbia's Fair Housing Act. This approach directly addresses the client's request by stating it cannot be fulfilled and immediately provides the legal basis for this refusal. It educates the client on the prohibition of discrimination in housing transactions and reinforces the salesperson's commitment to ethical and legal conduct. This proactive communication prevents any misinterpretation or perceived complicity in discriminatory practices. Incorrect approaches analysis. One incorrect approach involves agreeing to the client's request and attempting to subtly steer them away from certain areas or properties without explicitly mentioning the discriminatory nature of their preference. This is professionally unacceptable because it implicitly condones the client's discriminatory intent and risks actual discriminatory actions, even if unintentional. It fails to educate the client and leaves the salesperson vulnerable to accusations of complicity. Another incorrect approach is to ignore the discriminatory aspect of the request and proceed with showing properties that align with the client's stated preference, assuming it's a matter of personal taste. This is a significant regulatory and ethical failure. It demonstrates a lack of understanding or willful disregard for fair housing laws, potentially leading to the perpetuation of housing segregation and discrimination. The salesperson has a duty to act in accordance with the law, not to facilitate potentially discriminatory outcomes. A further incorrect approach is to refuse to work with the client altogether without providing any explanation. While avoiding direct involvement in a discriminatory transaction is a goal, a complete refusal without explanation can be perceived as unprofessional and may not effectively educate the client about why their request is problematic. It misses an opportunity to uphold fair housing principles and could lead to the client seeking services from less scrupulous agents. Professional reasoning. Professionals in British Columbia must adopt a decision-making framework that prioritizes legal compliance and ethical conduct. When faced with a request that may lead to discrimination, The first step is to identify the potential for contravention of the Fair Housing Act. The next step is to communicate clearly and directly with the client, explaining the legal prohibitions against discrimination in housing. This communication should be firm but polite, focusing on the law rather than personal judgment of the client. The salesperson should then offer to assist the client in finding suitable housing that complies with all legal requirements. This process ensures that the salesperson acts as a responsible and ethical representative of the real estate industry. Question 16. The risk matrix shows a potential for undisclosed financial incentives in a real estate transaction in British Columbia. A salesperson representing a buyer is approached by the seller's agent with a proposal for a direct commission rebate from the seller's brokerage to the buyer's salesperson, bypassing the buyer's brokerage, in exchange for expediting the closing process. What is the most appropriate course of action for the buyer's salesperson? Option A. Negotiate a reduced commission with the seller directly, suggesting that if the buyer agrees to a faster closing, the seller can reduce the overall commission paid. Option B. Decline the direct commission rebate offer and ensure all commission is paid through the respective brokerages as per standard practice and regulatory requirements, while advising the client of the standard commission structure. Option C. Accept the direct commission rebate from the seller's agent, as it would benefit the salesperson personally and potentially lead to a faster closing for the client. Option D. Agree to a verbal understanding with the seller's agent to receive a portion of the commission directly, without informing the buyer or their own brokerage. The correct answer is B. Decline the direct commission rebate offer and ensure all commission is paid through the respective brokerages as per standard practice and regulatory requirements, while advising the client of the standard commission structure. Explanation. This scenario is professionally challenging because it involves navigating potential conflicts of interest and ensuring transparency in commission arrangements, which are heavily regulated in British Columbia. Real estate professionals must uphold their fiduciary duty to clients while also managing their own financial interests. The Real Estate Services Act, RESA, and its associated rules are paramount in guiding these arrangements. The best approach involves clearly disclosing all commission-related information to the client in writing, as required by RESA and the rules. This includes any arrangements that might influence the salesperson's recommendation or create a perceived conflict. Transparency builds trust and ensures the client can make informed decisions. Specifically, the rules mandate that a brokerage must not pay remuneration to a salesperson unless it is paid by the brokerage, and that a salesperson must not accept remuneration from anyone other than their brokerage. Furthermore, any agreement regarding commission must be in writing and clearly outline the terms. An incorrect approach would be to accept a direct commission payment from the seller's agent without the knowledge and consent of the buyer, and without it being processed through the buyer's brokerage. This violates the rules by circumventing the brokerage's role in handling remuneration and creates a significant conflict of interest. It also fails to provide the buyer with full transparency regarding the financial incentives influencing their transaction. Another incorrect approach is to agree to a verbal commission split with the seller's agent, hoping to keep it informal. This is problematic because RESA and the rules require all commission arrangements to be in writing. Verbal agreements are unenforceable and lack the necessary transparency and accountability. It also bypasses the brokerage oversight and the client's right to know the full financial picture. Finally, an incorrect approach would be to suggest to the buyer that the commission can be reduced if they agree to a faster closing, implying a direct negotiation of commission outside of the standard brokerage agreement. This misrepresents how commissions are structured and paid in British Columbia, potentially misleading the client about their financial obligations and the salesperson's role. It also creates an undue pressure on the client and blurs the lines of professional conduct. Professionals should always prioritize clear, written disclosure and adherence to the regulatory framework. When faced with commission-related discussions, they should ask themselves, is this arrangement fully disclosed in writing to all parties involved? Is the remuneration being handled through the proper brokerage channels as mandated by RESA? Does this arrangement create any potential conflict of interest? And if so, has it been managed ethically and transparently? Question 17. Investigation of a potential buyer's interest in a property in Surrey, British Columbia, has led the real estate salesperson to believe a quick offer is possible. The buyer expresses eagerness to proceed and asks if the buyer representation agreement can be signed quickly without much discussion, as they have bought property before. What is the most appropriate course of action for the salesperson to ensure compliance with British Columbia's real estate regulations and ethical standards? Option A. Present the buyer representation agreement as a standard document and encourage the buyer to sign it promptly to facilitate the offer process, given their stated desire for speed. Option B. Focus primarily on drafting the offer to purchase, assuring the buyer that the buyer representation agreement is a formality that can be addressed later once the offer is accepted. Option C. Thoroughly explain all clauses of the buyer representation agreement, including the salesperson's remuneration, the duration of the agreement, the scope of services, and any potential conflicts of interest, ensuring the buyer understands each aspect before signing. Option D. Assume the buyer's prior experience negates the need for a detailed explanation of the buyer representation agreement and proceed with a brief overview before obtaining their signature. Correct answer is C. Thoroughly explain all clauses of the buyer representation agreement, including the salesperson's remuneration, the duration of the agreement, the scope of services, and any potential conflicts of interest, ensuring the buyer understands each aspect before signing. Explanation. This scenario is professionally challenging because it requires a real estate salesperson in British Columbia to navigate the complexities of buyer representation agreements, specifically concerning the disclosure of potential conflicts of interest and the salesperson's duty to act in the best interests of their client. The salesperson must balance their professional obligations with the client's desire for a quick transaction, ensuring that all legal and ethical requirements are met. Careful judgment is required to avoid misrepresentation or breaches of fiduciary duty. The best professional approach involves clearly and comprehensively explaining the terms of the buyer representation agreement to the buyer, including the salesperson's remuneration structure and any potential conflicts of interest, before the agreement is signed. This approach is correct because Section 3-4 of the Real Estate Services Act, RESA in British Columbia, mandates that a trading services representative must, at the earliest practicable opportunity, disclose to the client all material information relevant to the transaction, including any potential conflicts of interest. Furthermore, the Real Estate Services Regulation requires that a written service agreement be entered into, outlining the terms of the relationship. Full disclosure and understanding of the agreement by the buyer are paramount to fulfilling the salesperson's fiduciary duty and ensuring informed consent. An incorrect approach involves presenting the buyer representation agreement as a mere formality and encouraging the buyer to sign it quickly without a thorough explanation of its implications. This fails to meet the statutory requirement for disclosure of material information and the salesperson's duty to ensure the client understands the agreement. It also breaches the ethical obligation to act in the client's best interests by potentially leading them to agree to terms they do not fully comprehend, which could result in a conflict of interest or a disadvantageous arrangement. Another incorrect approach is to downplay the importance of the buyer representation agreement and focus solely on finding a property, implying that the agreement is secondary to the immediate goal of securing a sale. This neglects the legal and ethical foundation of the buyer-salesperson relationship. The agreement establishes the terms of engagement and the salesperson's responsibilities, and failing to adequately address it undermines the professional relationship and potentially violates RESA requirements regarding written service agreements. A further incorrect approach is to assume the buyer is fully aware of the implications of a buyer representation agreement due to prior real estate experience, and therefore proceed with minimal explanation. While a buyer may have prior experience, each agreement can have unique clauses and implications. The salesperson's duty of care and disclosure is ongoing and cannot be waived based on an assumption of the client's knowledge. This approach risks overlooking specific details that are material to the current transaction and the client's specific needs, thereby failing to uphold the salesperson's fiduciary obligations. The professional decision-making process for similar situations should involve prioritizing full and transparent disclosure, ensuring client comprehension of all contractual obligations and potential conflicts, and adhering strictly to the requirements of the Real Estate Services Act and its regulations. Salespersons should always err on the side of providing more information rather than less, and confirm that the client has had sufficient opportunity to ask questions and understand the agreement before signing. Question 18. Comparative studies suggest that real estate salespersons in British Columbia often face challenges in clearly communicating the nuances of different listing agreements to their clients. A seller in Vancouver is seeking to list their property and expresses a desire for maximum market exposure, while also wanting to retain the possibility of selling the property themselves without owing a commission. Which approach best addresses the seller's stated objectives and the salesperson's professional obligations under British Columbia's real estate regulations? Option A. Present only the exclusive right to sell listing agreement, emphasizing its broad market exposure and the certainty of commission for the brokerage. Option B. Focus the discussion primarily on the commission percentage offered by the brokerage, assuring the seller that a lower percentage will lead to more buyer interest. Option C. Recommend the exclusive agency listing agreement as the primary option, highlighting the seller's ability to avoid commission if they find the buyer. Option D. Thoroughly explain the differences between an exclusive right to sell listing and an exclusive agency listing, detailing how commission is earned in each scenario and the implications for the seller's ability to sell the property independently. The correct answer is D. Thoroughly explain the differences between an exclusive right to sell listing and an exclusive agency listing, detailing how commission is earned in each scenario and the implications for the seller's ability to sell the property independently. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate salesperson in British Columbia because it requires them to balance the seller's desire for maximum exposure and potential for a quick sale with the legal and ethical obligations to clearly explain the implications of different listing agreements. Misrepresenting or failing to fully disclose the terms and consequences of an exclusive right to sell versus an exclusive agency listing can lead to disputes, commission claims, and damage to the salesperson's reputation and licensing status. The salesperson must demonstrate a thorough understanding of these agreements and their impact on the seller's financial and legal position. Correct approach analysis. The best professional practice involves clearly and comprehensively explaining the fundamental differences between an exclusive right to sell and an exclusive agency listing agreement to the seller in British Columbia. This includes detailing that under an exclusive right to sell, the seller agrees to pay the listing brokerage a commission regardless of who procures the buyer, including if the seller finds the buyer themselves. This approach is correct because it aligns with the Real Estate Services Act, RESA, and the Real Estate Services Regulation, which mandate that registrants must act honestly and with integrity, and provide clients with information and advice that is in their best interest. Specifically, RESA requires registrants to disclose all material information that might affect a client's decision. By thoroughly explaining both options, the salesperson empowers the seller to make an informed choice that best suits their circumstances and risk tolerance, fulfilling their fiduciary duty. Incorrect approach is analysis. Presenting an exclusive right to sell agreement as the only option, without adequately explaining its implications or offering alternatives, is professionally unacceptable. This fails to meet the obligation to provide informed consent and may mislead the seller into agreeing to terms they do not fully understand, potentially leading to disputes over commission if they introduce a buyer themselves. This approach violates the duty of full disclosure and could be seen as prioritizing the brokerage's potential for commission over the client's best interests, suggesting that an exclusive agency agreement is always superior because it allows the seller to avoid commission if they find the buyer themselves, without also explaining the potential downside of reduced marketing efforts by the brokerage or the risk of the seller inadvertently introducing a buyer who was already exposed to the property by the brokerage, is also professionally flawed. While it highlights a benefit, it omits crucial context and potential risks, failing to provide a balanced perspective necessary for informed decision-making. Focusing solely on the commission rate, without detailing the fundamental differences in how commission is earned under each type of listing agreement, is insufficient. Commission rate is only one factor. The core issue is the scope of the brokerage entitlement to commission, which is determined by the type of listing agreement. This approach neglects the critical legal and contractual distinctions that are paramount to the seller's understanding. Professional reasoning. Professionals should approach listing agreement discussions by first understanding the seller's objectives and risk tolerance. They must then clearly articulate the key features, benefits, and drawbacks of each available listing agreement type, using plain language and providing concrete examples. The salesperson's role is to educate and advise, not to pressure or mislead. A thorough explanation, allowing the seller to ask questions and make an informed decision, is the cornerstone of ethical and legally compliant practice in British Columbia. Question 19. The investigation demonstrates that a real estate salesperson in British Columbia has been approached by a seller to list their property, and shortly thereafter, by a potential buyer who has expressed strong interest in purchasing that same property. The salesperson is considering how to proceed with this situation. Which of the following approaches best reflects the required professional and regulatory conduct in British Columbia? Option A. Represent the buyer, as they have expressed immediate interest, and inform the seller that the salesperson can no longer advocate for their best interests. Option B. Obtain informed written consent from both the seller and the buyer after fully disclosing the implications of dual agency and how the salesperson will manage the transaction fairly. Option C. Proceed with representing the seller as they were the first client, and advise the buyer to seek independent representation. Option D. Assign the buyer to another salesperson within the same brokerage, without informing either party about the initial seller-client relationship. The correct answer is B. Obtain informed written consent from both the seller and the buyer after fully disclosing the implications of dual agency and how the salesperson will manage the transaction fairly. Explanation. This scenario presents a professional challenge due to the inherent conflict of interest that arises when a real estate salesperson attempts to represent both the seller and the buyer in the same transaction in British Columbia. The Real Estate Services Act, RESA, and its associated rules are designed to protect the public and ensure fair dealings in real estate transactions. Navigating dual agency requires strict adherence to disclosure and consent requirements to avoid misrepresentation and breaches of fiduciary duty. Careful judgment is required to ensure all parties are fully informed and have provided informed consent, or to decline the representation if such consent cannot be obtained ethically and legally. The best professional approach involves obtaining informed written consent from both parties after full disclosure of the implications of dual agency. This means clearly explaining to both the seller and the buyer that the salesperson's duty of loyalty is divided, and they cannot advocate exclusively for either party's best interests. The salesperson must outline how they will manage the transaction, ensuring fairness and transparency. This approach is correct because it directly aligns with the requirements of RESA and the rules, which mandate disclosure and consent for dual agency. It upholds the salesperson's ethical obligations to act with honesty and integrity while managing a potentially conflicted situation. Representing both parties without obtaining explicit, informed written consent after full disclosure is a significant regulatory and ethical failure. This approach breaches the salesperson's fiduciary duty to each party, as they cannot simultaneously prioritize the best interests of both the seller, e.g., achieving the highest possible price, and the buyer, e.g., negotiating the lowest possible price. This failure to disclose and obtain consent can lead to allegations of misrepresentation and a violation of RESA. Another incorrect approach is to proceed with the transaction by prioritizing the interests of the party with whom the salesperson has the longest standing relationship, or the party who offers a higher commission. This is ethically unacceptable and a violation of RESA. The salesperson's duty is to act in the best interests of their client, and in a dual agency situation, this duty is inherently compromised and must be managed through disclosure and consent, not by favoritism. Finally, attempting to avoid the dual agency issue by having another salesperson from the same brokerage represent one of the parties, without proper disclosure and consent regarding the brokerage's knowledge and potential influence, can also be problematic. While a designated agency model might be permissible under certain circumstances, it still requires transparency and informed consent from all parties involved regarding the brokerage's role and the limitations of individual salesperson representation. Simply assigning the other party to a colleague without full disclosure and consent can still create conflicts and misrepresent the nature of the representation. The professional reasoning framework for such situations should involve 1. Identifying the potential conflict of interest immediately. 2. Consulting RESA and the rules regarding dual agency. 3. If dual agency is contemplated, preparing a comprehensive disclosure statement outlining all potential conflicts and limitations. 4. Obtaining informed, written consent from all parties before proceeding. 5. If informed consent cannot be obtained, or if the conflict is too significant to manage ethically, declining to represent one or both parties. Question 20. Assessment of the total financial implications for a client purchasing a property in Vancouver, British Columbia, requires a thorough understanding of mortgage structures. A client is considering two mortgage options for $500,000 loan with a 25-year amortization period. Option 1. A fixed-rate mortgage at 4.5% annual interest, compounded semi-annually, not in advance. Option 2. An adjustable-rate mortgage with an initial rate of 4.0% annual interest, compounded semi-annually, not in advance. This rate is subject to change annually, with projections indicating it could increase to 4.75% in year 2, 5% in year 3, 6, 25% in year 4, and 7.0% in year 5. Assuming the client intends to keep the mortgage for exactly 5 years, what is the approximate total amount of interest paid over this 5-year period for each mortgage option? Option A. Fixed-rate mortgage, approximately $105,000 in interest. Adjustable-rate mortgage, approximately $128,500 in interest. Option B. Fixed-rate mortgage, approximately $105,000 in interest. Adjustable-rate mortgage, approximately $119,000 in interest. Option C. Fixed-rate mortgage, approximately $116,500 in interest. Adjustable-rate mortgage, approximately $119,000 in interest. Option D. Fixed-rate mortgage, approximately $116,500 in interest. Adjustable-rate mortgage, approximately $128,500 in interest. The correct answer is D. Fixed-rate mortgage, approximately $116,500 in interest. Adjustable-rate mortgage, approximately $128,500 in interest. Explanation: Scenario analysis. This scenario presents a professional challenge for a British Columbia real estate salesperson by requiring them to accurately calculate and compare the total cost of two different mortgage types over a specific period. Miscalculation or misunderstanding of how interest accrues and principal is paid down can lead to providing inaccurate advice to a client, potentially resulting in financial detriment for the client and professional repercussions for the salesperson. The salesperson must demonstrate a clear understanding of mortgage amortization and the impact of interest rate changes on the overall cost of borrowing. Correct approach analysis. The best professional approach involves calculating the total interest paid and the principal reduction for each mortgage scenario over the 5-year term. For the fixed-rate mortgage, this requires using a standard mortgage payment formula and then summing the interest paid over 60 months. For the adjustable-rate mortgage, it necessitates calculating the initial payment, then projecting the interest and principal payments for each year based on the anticipated interest rate changes, and finally summing all payments and interest. This method provides a comprehensive and accurate comparison of the total financial commitment for the client under each mortgage option, allowing for informed decision-making. This aligns with the ethical obligation under the Real Estate Services Act, BC, and the Real Estate Services Regulation to act with honesty and integrity, and to provide competent service, which includes accurate financial information. Incorrect approach is analysis. One incorrect approach would be to only compare the initial monthly payments of the two mortgages. This fails to account for the total interest paid over the 5-year period and the principal reduction, which are critical components of the overall cost of borrowing. It also ignores the potential for significant increases in payments with an adjustable-rate mortgage, leading to a misleading comparison. This approach violates the duty of competence and the obligation to provide accurate information. Another incorrect approach would be to only calculate the total principal paid back over the 5 years for each mortgage. This overlooks the most significant cost of borrowing, interest. Without considering the interest paid, a client cannot understand the true cost of each mortgage option. This demonstrates a lack of understanding of mortgage finance and a failure to provide complete and accurate advice. A further incorrect approach would be to assume the adjustable-rate mortgage will remain at its initial rate for the entire 5 years and calculate payments based on that assumption. While this might simplify the calculation, it is a flawed assumption that does not reflect the nature of an adjustable-rate mortgage. This misrepresentation of how an adjustable-rate mortgage functions can lead to significant underestimation of future costs for the client, violating the duty of honesty and integrity. Professional reasoning. Professionals should always prioritize accuracy and completeness when providing financial information to clients. This involves understanding the nuances of different financial products, such as fixed-rate versus adjustable-rate mortgages. A systematic approach, involving detailed calculations for each scenario over the relevant time period, is essential. When faced with complex financial calculations, it is prudent to use reliable financial calculators or software, and to clearly explain the assumptions made and the methodology used to the client. If unsure, seeking clarification or additional resources is a sign of professional responsibility.